All right, ladies and gentlemen, let's go ahead and get started. Ms. Ogden, will you call the roll?
Senator Albritton, Senator Bell, Senator Carnley, Senator Coleman Madison, Senator Elliott, Senator Figures, Senator Gavan, Senator Orr, Senator Singleton, Senator Smitherman, Senator Stutz, Senator Weaver, and Senator Barfoot.
Here.
8, and we have a quorum.
We've got a quorum. We're going to show the, what's your official title? I forget. I'm brain dead. Pro Tem, House Pro Tem, some courtesy this morning. He's got a meeting he's got to get to, so we're going to kind of jump out of order. Representative Pringle, HB 10.
Thank you, ladies and gentlemen, and Mr. Chairman. This is HB 10. This was the fentanyl bill we passed last year that on the last night they attached the wrong amendment to it and it killed the bill. So we brought it back. It still has Senator Smitherman's amendment that he put on the bill. But there's a different amendment this year. The change is the way knowingly is put in. It was a compromise with me and Representative England that the DA's approved. It has the word knowingly selling fentanyl products. So,
had a first motion for favorable by Senator Bell, second Senator Gavan. Any discussion? I think this bill passed the House.
Yeah, with the amendment on it passed unanimously.
Yeah. Okay. All right. Any discussion on the bill? Hearing none. Holly, if you'll call the roll for us.
Senator Albritton, Senator Bell, Senator Carnley, Senator Coleman Madison, Senator Elliott, Senator Figures, Senator Gavan, Senator Orr, Senator Singleton, Senator Smitherman, Senator Stutz, Senator Weaver, and Senator Barfoot.
Aye.
8.
All right. Bill's giving favorable report. Thank you.
Thank you.
Thank you. All right, let's jump back on the regular order. Senator Smitherman's not here, so let's go down to SB 119, Senator Stewart.
Good morning. It's an honor to address this august committee, SB 119. This is nothing new. All it does is it increases the criminal penalties for employers who violate our current child labor laws. And it is a bipartisan bill. I had help from Senator Orr on this legislation. And so under existing law, an employer who violates our child labor laws, they are subject to civil and criminal penalties. And the bill, we did get an amendment from DOL. They wanted some flexibility on how to carry out this law. Previously in the bill, we said that they must, but we changed to may impose the civil penalty of not less than $300 for less egregious instances.
Thank you, Senator Stewart. The amendment, I think there is an amendment that we need to adopt. Is there a motion to adopt the amendment? You've got first and seconds all over the place, so any opposition to using previous rule on adopting that amendment? Hearing none, if you will put Senator Smitherman on there. Okay, then the amendment is adopted. Any further discussion on the bill? Got a motion for favorable and a second by whoever we want to pick on here. All right. Motion and a second on the bill as amended. Any further discussion? All right. Using previous rule, no opposition. Thank you, Senator Stewart.
Thanks for caring about the children.
Thank you. All right, Senator Smitherman, back up to you at the top of the order.
This bill amends existing laws and require occupational license to determine whether an individual criminal conviction is qualified and the life and be published on the website of the qualifying criminal officer.
Got a motion for favorable by Senator Orr. Senator Smithman, if you will, I think, will you make sure the microphone's on so those folks online can hear you?
Thank you. I don't know if it was, let me see. It was, okay, we straight. I had to remember someone was talking to me about it, and then they said that, yes, everything looked good. So we're straight. It was one of our professions, but they said that it was okay with what was there, so we okay.
Okay, we've got a first and a second. Any further discussion on the bill? Senator Albritton.
I'm just a little bit confused. This, as an individual who is who's been convicted of a criminal offense at any time may request that an occupational license board determine whether the individual's criminal conviction disqualifies the individual from obtaining a license from the board. So I'm assuming that most licensure boards require someone, one of their licensees has to report if they get a criminal conviction, correct?
That, and also to give you what in relationship to what you're saying, they also have certain background checks they do anyway, and what it does, it as well, it allows them to take the totality of the situation and then to be able to make a determination versus just on its face. So that's why once they go in, they're able to do this. It's almost kind of like the judge, you know, when they hear all the different aspects of what take place, then they make a determination of whether or not they think that it may or may not.
So this is really giving the licensee an opportunity to give their side of the story. Is that
Right.
an accurate statement?
That's pretty accurate. And then they'll make a determination whether or not they ought to get it.
Okay, thank you.
And Senator Smithman, I'm in favor of the bill. When I was reading through there over the weekend, there was something that about who's supposed to supply that information. I think reading the amended part, Section A of 419A-2, an individual who has been convicted of any criminal offense at any time may request the Occupational Licensing Board determine whether the individual's criminal conviction disqualifies the individual from obtaining a license from the board, period. Any individual making a request shall include details of the individual's criminal conviction and required fee as provided in Section C. And I think my question was, and I don't have my notes that I'd made, but was how does that board get that information? In other words, if I'm applying for a license, I can just say, you know, well, it was just a theft, and I'm assuming there's more information than just my statement. Anyway, I may want to talk to you about that, but support the bills.
Yeah, it's the normal steps for a background check doesn't change.
Okay.
This is just an addition if they won't be able to provide that, and then that's into the whole mix for them to make a determination. But that doesn't change. And I said smilingly because in another life, I was, in charge of human resource for a multinational corporation, so I know I did plenty of these background checks on folks and stuff.
Well, when I looked through here, I thought about whenever I was going through law school. You make your application, and then right before you can sit for the bar, they bring you in or can bring you in and tell you, "I'm sorry, you can't take it," even though you've gone through 2+ years or maybe almost 3 at that point of law school. I actually got called in to the state bar, and it happened to be because I had running a stop sign ticket whenever I was 20-something years old, and maybe a failure to yield or something. And I thought, I was nervous as I could be. I thought I've spent almost 3 years of my life, and these people may tell me I can't take the bar exam. So anyway, that was.
Are you gonna put that on your TV ad?
I might. if I could still have TV ads after this session. I don't know. So, all right.
Ooh, I'm intrigued now.
Yeah.
I just realized what you said.
Yeah. All right. Do we have a first and a second? Already have a first and a second. Any opposition to using previous role? Senator Carnley added as a yes. Bill's given favorable report.
Thank you
so much.
Thank you, Mr. Chairman and members.
All right. Next bill is HB 42. Representative Gibbons. Good morning.
Good morning, Mr. Chair and committee members. HB 42 is the human trafficking bill. If you'll remember, Governor Ivey spoke of this in her State of the State address. And Did you have a question?
Go ahead, and
No,
explain.
ma'am.
Oh, okay, I'm sorry. You were raising your hand. I'm sorry.
You gonna like what I'm.
We're going to want to move favorable pretty quickly.
That's,
You want favorable pretty
that's
quick?
really-
All right, then I'll make it short. It's human trafficking. If you're caught, you're 19 years of age or younger, we have an amendment for that. But if you're 19 years or older, it's a mandatory life sentence.
So when you said you had an amendment, I don't have an amendment here.
Oh, I've got it right here to pass out.
That was that an amendment for us, or was that an amendment that was adopted already in the House?
Amendment that was brought to me yesterday
Okay.
by, hold on, I'll tell you the initials. OPS.
We'll get those passed out.
And I do have Jeff Bradley here to speak on that, where he can make you all understand it better than I can, what
Thank
the
you.
amendment does.
Senator Smithman, do you want to be recognized now, or do you want to hear from Mr. Bradley?
I'll let
Okay.
them finish, Mr. Chairman. Thank you very much.
Representative Givens, if you want, Mr. Bradley to come up now?
Sure, that'll
Okay.
be fine.
Mr. Bradley?
Good morning, ladies and gentlemen. My name is Jeff Bradley. I'm the General Counsel for the Office of Prosecution Services. We talked to Representative Givens yesterday about a potential amendment to kind of clarify and clear up the language of the amendment that was added in the House Judy Committee. When it was there last week, they put on an amendment. It was as you can see in the sub, it's the yellow highlighted. It's the second sentence that talks about, however, somebody is 18 years or younger, they're to be sentenced as a Class A felony. Our concern with the way that was phrased is if you look at the way the courts have interpreted similar language from the Habitual Felony Offender Act, what that would do quite arguably is anybody that's 18 or younger, they would never be subject to the Habitual Offender Act if they violated this particular code section. So what our amendment was to do was to try to do what the House committee wanted to do, as well as Senator Givens' original intent. So we amended the sentence to where it would read, in any prosecution under this section where the defendant is 19 years old or older and there's a minor trafficking victim, the court shall sentence to a minimum of life imprisonment. That encapsulates and incorporates both the House committee amendment as well as her original intent, but it does it in a cleaner way that hopefully wouldn't be interpreted by the courts as limiting the application of the Habitual Offender Act to those that are 18 or younger.
There's a motion to adopt the amendment. Senator Smithman, you want to be recognized, or is that?
Yeah, after you do what you don't want to like to be recognized.
Got a second by Senator Orr, Senator Smithman.
Thank you. First, I want to say that I agree with what you're trying to do here about the human trafficking. I just want to make that very clear to you that I'm in full support of addressing what we need to do with this. I don't know if you all have been keeping up with the Junior League and their efforts in this human trafficking up in Birmingham, the Junior League, those women, but they've got an ongoing campaign, a serious one, with dealing with this issue.
Okay.
And it's right, it's in my face every morning because my daughter chairs that group.
Oh, very good.
This is one of her passions, this human trafficking thing and issue. And so I had to say that to you first to let you know that I'm engraving what you're doing. My concern is not the punishment. My concern is the lack of any involvement that the judge is going to be able to have when it comes to this. I'm just a believer in judicial discretion because each fact situation has to be measured by itself, and I also know what and most people in here know it, but all these lawyers definitely know when I say this. My thing is I'm concerned about constructive, and I think y'all know what I'm talking about, and that is you got somebody who's in this car and who's in this, I'm just saying not the traffic person, not the person who's doing it, but you got somebody else in that car who was there against their will, and now that other person in that car is going to get this same sentence right here. See, and a judge can make that determination right there, because if you use it for prima facie, and this is prima facie when it's a shell, there's no room for if that person was not know they were going where they were going, and then all of a sudden the person may have put up some resistance saying, I'm not with this or whatever, but the fact that they're in that car, and I know a response is coming, but I just want you to know I'm a lawyer, by the way. So I understand when I tell you that in that car, that meant that person is going to be hauled off for life, just like the one who you really trying to get, who's actually doing it. And I realize that there may be some situations that other person in there is the person, but you got to let the judge hear all the facts and then say that, no, both of y'all is getting life, or this person is not. That's what concerns me about this amendment. So I just wanted to say that I'm really concerned about the lack of judicial discretion on any situation. This is Katie bar at the door. There's nothing the judge can do if they sit there and hear what I just said. By law, they're bound to do this, and so I'm very concerned with that. And I probably won't vote for the amendment, but I am a full supporter of what you're doing and the bill. But it's just that I'm just concerned about that aspect.
Okay, thank you.
Thank you, Senator Smitherman. Any other discussion? Senator Cole Madison.
I would like for the gentleman who brought this amendment and is explaining to address, because it's the same concern that I had. I mean, there are a lot of times we know that people are in the car, you pick somebody up and say, come on, go with me. And then something is going on and you may have somebody in the back seat and that's being held hostage for this purpose, and you don't know. And so that was my concern, again, is that this doesn't leave any room. It's just, okay, you with them, you part of the group, and so everybody gets caught up. You throw that net out and everybody gets caught up. I just would like for you to address this and maybe how this can be addressed, because I can see a lot of people being caught up, and then, there's no room. I guess there's no appeal for this or whatever, but can you explain your opinion about this?
Yes, ma'am. And I guess where I would start with that is all of the elements of this, they require at least knowingly. If you look up on page 1 in section A1, they have to knowingly subject another to sexual servitude. So that knowingly subjecting them to that would have to be proven beyond a reasonable doubt before they could be convicted and then be subject to the mandatory life sentence. Additionally, section 2, they have to knowingly obtain, recruit, solicit, all those other things to cause a minor to engage in sexual servitude. So that knowingly on their part would have to be proven beyond reasonable doubt to a jury, and a jury would have to return that verdict of, yes, I believe this person knowingly did that, before they would be subject to this sentence. Similarly, in section 3, they have to knowingly give monetary consideration for any sexual conduct with a minor. So again, giving monetary consideration for sexual conduct with a minor, that they knowingly did that would have to be proven beyond a reasonable doubt to a jury before they would be convicted and subject to this potential penalty. And a lot of times, I know just from in my time in the district attorney's offices, if you have somebody that's in the car like that, they would be much more valuable in a potential prosecution against the main ne'er-do-well. If they were in there and they only saw bits and pieces of it, that they would be a witness against that person, and quite often that they would turn into that. Also, if the identified victims of that, they would also not be prosecuted. So hopefully, if the process works as it's designed, because the prosecutors would have to prove knowingly that they did these things. If it's just somebody that's in there that really does not know what's going on, they wouldn't be able to prove that knowingly element to the jury in order to have them convicted of the offense.
Senator
Does
Smith.
that help?
I'm not gonna put late because we got other meetings and things, but I want to say, I understand what you're saying, you know, and I agree in part with what you're saying in I hate to say it this way, but I just have to say it this way. I agree with what you're saying in your world, your life. You know, you're accurate in what you're saying. I mean, because of your experiences and you know that, but I'm just gonna tell you, in the world that I live, it ain't gonna happen like that. They're not gonna get the benefit of the doubt. And that's what you're saying, based on the situation, they're not gonna do that. I mean, I could just tell you, I went to a track meet Monday night. My grandson, school bus went and parked at the wrong place. The track coach had to go find the school bus. I'm standing down there with 12 or 14 kids outside of this track stadium, okay, and at the school. And I'm down there, it's a little cool. I'm down there with my daughter, by the way, and my oldest. And I'm standing up there, so I had my thing on, I had my hood over my head. You know, that's you. She said, Them folk came down there and with the police walking down there asking, what are y'all doing down here? I'm the state senator. What am I doing down here? And the coach asked me to watch the kids so while she go find the bus. But what are you doing down here? Then when they realized where I was, they said, oh, it's you, senator? And they start smiling and say, it's all right.
Sure.
Only because I was the senator. Before they walked down there, I was just another black guy with a hoodie on his head. I mean, I'm just saying what happened, you know. So that's all that I'm saying. In that you still got a lot of room for the discretion. Okay. And the last thing you said about testifying, and I'm through, Mr. Chairman. I say this. Let me just say it like this: in the world I live in, and you know, in the urban area,
Yes, sir.
you know what will happen to that person? I'm gonna tell you what happened to that person.
Yes,
The minute they did that, then them people gonna put a hit out on their people. You see what I'm saying? The one where the 4 people was killed on the news, 2 of them was targeted. When you hear the police say targeted, that's a hit. And then the other 2 were just killed innocently because they were there. But so what I'm saying, in the real world, it don't work like what you said. Not in the world I see.
Yes, sir.
And so you still got to give the judge, in my opinion, I'm through, some discretion so that they can at least, you know, deal with it. They may stay the same, but you got a lot of room. Thank you, Mr. Chairman.
Thank you, Senator Smitherman. Any other discussions on the amendment?
Wondering if the sponsor of the bill would be willing to work with, we could come up with something that put that type of language that Senator Smitherman is talking about specifically. And I know that the gentleman alluded to the fact that, you know, you have these things that's already in here, but sometimes, again, we make the law, but we don't interpret the law. In order to clarify and to be specific, if something goes to court, that the judge has discretion so that these things can be looked at separately. Doesn't change your bill. It still allows them to do whatever they need to do, but it clarifies that situation so that things are not interpreted in a narrow, Senator Smithman, I quote him all the time, using about the airplane. So it's interpreted with the intent of what you want to do here.
Okay, one thing I would like to make a point here, if the individual that has been abducted for trafficking would be able to testify that the gentleman or female sitting in the passenger seat had nothing to do with it. They were abducted by, say, the driver of the car or number 1, whoever that was or may be. So I think the individual that has been targeted, that has been abducted, would be able to testify and say, you know, this person is not guilty, only this one is the one that abducted me or did whatever to me. So I think that in itself would clear up what you all are concerned about.
I would just say that don't clear up a conspiracy. Conspiracy that, you know, you plan to do it. And believe me, the one getting caught gonna take the other one down with him. He gonna tell it whether the person had anything to do with it or not. So I understand what you're saying, but from that perspective, conspiracy, that person will not know before they get abducted that these people did or did not. So it doesn't clear them. Thank you very much, but I just want you to know that that doesn't cure it. Like, I wish it did, but it doesn't.
All right.
I'm ready, Mr.
Thank you.
Chairman.
All right, any further discussion on the amendment? Hearing none, is there a motion to adopt the amendment? Let me say this before we go on to adopt the amendment, and I just went and checked with LSA. I'm guilty of this, where I've had amendments and offered them before in different committees that were not in LSA format. I know we are desperately trying to get away from that. It's not an LSA format. I think it's going to fit because it is a one-line change in there. But in the future, members, I intend to try to enforce that rule. So I'm not trying to frustrate the system. I think we're going to adopt the amendment and we'll move the bill forward, it seems like, but just so y'all know and so everybody's listening will know, we need those in LSA format. So motion to adopt the amendment, is there a second? We already had a first and second. Have we already adopted the amendment?
Just count me as.
Just checking to see if you're paying attention. All right, any opposition using previous roll on adopting the amendment?
Vote me a no on the amendment.
No on the amendment. No on the amendment for Senator Coleman Madison. The amendment's adopted. Any further discussion on the bill? Motion for favorable, Senator Carnley, second by Senator Weaver. Any opposition using previous roll, or would y'all like to be added to the
I'm gonna vote for the bill.
yes column?
I'm voting yes for the bill.
Senator Coleman Madison, you would like to be a yes, so the bill's given a favorable report as amended. Thank you so much.
Thank you all. Have a great day.
Thank you. All right. Next up, we've got Representative Halsey, and I think Senator Smitherman, are you carrying this for Representative Halsey? It's the
This bill adds new statutory provision making it illegal for a jury member as a design to be involved in certain behavior conduct with minors. In fact, thank you. Anyway, thank you. I need help, so don't. I want y'all to know that if you see me in a position needing help, just help me like he did. Just tell me about why later. I won't even ask you. I can be on the floor to call up anything. Y'all just come help me, you know. But, all right. But actually, I was supposed to have the Senate bill in this, and you still may see me put it in the jacket, but we're going to pass, if you all agree with it, we're going to pass her bill. But yeah, it goes a long ways to protecting minors, and it puts a standard on clergy that how they should conduct themselves and not conduct themselves as it relates to their behavior with minors.
I think if memory serves me correctly, this bill came out of the House with a unanimous vote, I believe.
Yeah.
I would like to point out to the committee, Mike Harper, the attorney for the committee, does an excellent job on reviewing these and always providing some insight and maybe not suggestions, but just pointing out what tweaks are potential or what issues or concerns that from a legal standpoint they're seeing. Looks like, and I'm not, maybe this is the intent of the bill, but it looks like that if someone is, say the technical language, has an intellectual disability, and that person is over the age of 22 years old, that that person would not be affected by this statute. And I don't know if that's the intent of the bill or not, but somebody who, for instance, is under the authority of an individual with an intellectual disability who is over the age of 22, that clergy member is defined in this code section, could have relations with that individual since is over 22. Am I saying that correctly, Mr. Harper?
Yes, I think you are.
So anyway, that's just a potential concern for the committee to think about, and certainly that's something that maybe there'll be some discussion later on between the members, but just wanted to bring that up. So.
And I think her intent was to deal with the minors primarily. I think that was it. And that was got to that point. I think it comes with a threshold crossing over to adults.
Right, I understand. Senator Coleman Madison.
Thank you. I see where you're going with this. And I think at that point, you have to look at the intellectual capacity or not chronological age, but mental age of the person. you know, you could be 22, you know, you may not have the mental capacity of age 22. You may be of a 6-year-old, whatever. So I think this perspective that you're looking at, and for many of us, it would still fit in this category, but there's not a provision in here. So I see where you're.
Thank you, members. Senator Albright.
Thank you, Mr. Chair. Is this a whole new section? I mean, it looks, the crimes that's described in here, those are already crimes, aren't they?
Well, some of them are crimes, but some of them also go to the specific behavior that takes place in that. And so I think a lot of it has to do with how you dispense or disseminate. I guess that some of these are related to that as well.
Well, I was just thinking that we're defining targeting, if you will, clergy, and particularly, as I understand it, this is not lay clergy. This is employed clergy. Is that accurate? Is there a distinction there?
I don't know if it's that distinction exists in there or not. So.
Well,
I just, I'm being honest with you.
I understand.
Yeah.
It says any person regularly as a vocation. Now that's an or. But if this is a lay member that's a Sunday school teacher in something, do they fit into this criteria?
No, I think it primarily did with clergy.
I have some concerns about that clarification along that line. I'd like to talk to somebody about that.
Okay.
The other aspect is, are we boosting, since these are already crimes for others to commit, then is this an increase in penalties from that? That's unclear from this.
I think it's making it clear what actions are punishable. I don't see a person. I don't see the enhancement in that at all.
Oh, well, that's kind of my concern.
Yeah.
Is at the point that if they're a clergy member, they deserve greater punishment than someone that's not a clergy member.
No, that's not my understanding as being the intent at all.
I've got some issues. I'd like to talk to someone before we. I'm not going to hold the bill up, but I'd like to talk to someone and find out where we are on this matter. Because here, if this is a clergy member, and they commit a crime with someone, does it require that they be a member of their flock?
No, I don't know necessarily whether it does or doesn't.
I don't know if it does or not either. Anyway, those are some questions I got along this line I'd like to pursue.
Let me say this for you. I'm going to put a great smile on your face.
Please.
I look forward to talking to you about these and a few other issues. So I will be to see you. You don't have to look me over for this one, and these other ones neither. I will be in your office, I promise you. So everybody hear that. So you ain't got to worry about this one, y'all. We're going to talk about this one and a couple other little things we might
Wonderful. Look forward to it.
I know you do, Senator.
Senator Gavan, and then Senator Coleman Madison.
So I share some of, believe it or not, some of Senator Albrigh's concerns. And
Holy cow.
but also, I'm just curious. We list several specific types of clergy, yet we omit one of the world's largest religions from that, and I don't understand why. We don't have a mom in there.
A mom?
A mom. I-M-A-M. Imam. Muslim.
What's that?
Muslim priest.
Oh,
One of the world's biggest religions. We don't have them list. We list rabbi, we list pastor, and all that. I mean, if we're going to list them, it seems like we ought to list them. That's an easy amendment.
I mean, we didn't say it wasn't easy amendment. I just want you to know that nobody said
I'm
it
just
wasn't
bringing it
easy
up
amendment.
'cause-
But all the caveat you put on, no, nobody didn't say it wasn't. I don't have any problem with what you're saying. I just tell you that now. I hadn't talked to her, but I don't have any problem. I don't have any problem with what he's saying about clarifying whatever those issues are that he just said that at all. So I'll be glad to work with you on that, bring it on. I'll support it. I ain't no problem.
All right, members, any other discussion on the bill? Senator Coleman Madison, I'm sorry, Senator Coleman Madison, then Senator Singleton.
Thank you. I was wondering if Commission Minister would take care of your concern, but in reference to the learned attorneys who are going to be getting together to address this, I was just wondering, it says any as a vocation that any person who regularly as a vocation devotes substantial portion of his or her time and abilities to the service of his or her church and religious organizations. But so what do you consider substantial? I don't know if you want to kind of quantify that. You know, you have you have youth ministers and things like that. You have people who deal with sports, whether it's church or other things. But I'm just, how do you quantify that? And
Well, can I respond? Oh, I think if you look at bottom of page 1 in the definition where it's got clergy members, I think that addressed what he was saying and what you just said. And you go to page 2 at the top, that tells you who the class that they're talking about. When he was asking those questions, I should have guided him to that. It's down on line 28, and then it goes all the way to line 35.
I say commission minister.
So it lists all the people who would be involved with those children.
But I was just, again, wondering, how do you define a substantial amount of time on this? Because it's kind of
I think that would be discretion of the judge, you know, to make that call. Normally in reasonable time, it's not the same thing as usually 30 days. But in this, I guess it's determined the contact and whether or not it's in a lack of a better word, a supervisory capacity that they come to them and they have authority over them.
Senator Singleton? Okay. Any other further discussion on the bill? Hearing none, got a motion for favorable Senator Bell. Senator Smitherman will be the second on that. Any opposition to using you on the long roll? All right, Ms. Ogden, if you'll call the long roll for me.
Senator Albritton? No. Senator Bell? Senator Carnley? Senator Coleman Madison? Senator Elliott? Senator Figures? Senator Gavan? Senator Orr? Senator Singleton? Senator Smitherman?
Aye.
Senator Stutz? Senator Weaver? Senator Barfoot?
Aye.
10-1.
All right, bill's given favorable report. Thank you so much, Senator Smitherman.
Thank you all, members.
Thank you. Next up is HB 168, Representative Woods. Welcome to Judiciary, and I will tell the committee members we've taken this bill up. I think in its identical form as it was proposed by Senator Weaver. The substituted version that she had that we voted on in this committee, I believe, is identical to Representative Woods' bill. But Representative Woods, I'll let you tell us about it.
Thank you, Chairman Barfoot, members of the committee. You are correct that this is the identical bill that was passed last week by Senator Weaver. The purpose of HB 168 is to amend our state laws to treat AI-generated child pornography or child sexual abuse material the same way we treat actual child pornography. It also raises the age covered by our state child pornography law from age 16 to age 17. This bill also enables injured parties who bring civil actions against violators to receive actual and punitive damages. I'm honored to report that this bill passed in the House 2 weeks ago with unanimous bipartisan support.
Second.
A motion for favorable, second to Senator Smitherman. Any discussion on the bill?
One question, if I may.
Yes, sir, Senator
Is
Albert.
this the same one we talked about where AI is, we have to determine an age by AI?
It is identical to Senator Weaver's bill that we had some discussion on.
That was a yes? Oh, well, whatever I said last time, I say this time.
That's a good way of putting it.
Yeah. All right, any other discussion on the bill? Any opposition to using previous rule? Okay. All right, so
I didn't know you had a reservation. Okay. All right.
okay, all right. Just making sure. All right. Bill's given a favorable report. Thank you so much, Representative Woods.
Thank you, Mr. Chairman, members of the
That,
committee. Thank you.
Thank you. Seems to conclude Judiciary. Thank y'all. We won't see you next week, but we'll plan on seeing you the week after.